Hello students, I am Professor Dr. V.K. Sawant. We are concerned with Advanced Accountancy paper number 2, subtitled as Auditing. Now we are going to discuss company audit. In the previous lecture, in offline mode, we get certain information about company audit. In the present lecture, I would like to highlight qualification and disqualification of company auditor. That is one part. Second part, I would like to highlight that is removal of auditor from his duties. So, firstly, we are concerned with qualification of auditor. Then we will concern with disqualification of auditor, and later on we will concern with removal of auditor from his duties. We know that there are various forms of business organizations, namely sole trader, partnership firm, joint stock companies, public undertakings. It means departments run by government, and there are certain kind of sectors which are concerned with cooperative. So company is very famous and popular form of business organization in all over the world. Most of people are engaged in the business activities. Therefore, they are preferring to choose a company form of business organization. In company form of business organization, capital is raised through issue of shares, and it means that contribution of many people accumulated, and that's become share capital of a company. On the basis of that capital, we are trying to develop our business. So company is an artificial person created by law. It means that a company is not natural person like us. A company is an artificial person created by law. A separate law is passed. Presently, we are concerned with the Companies Act 2030. So, on the basis of that act, every company came into existence. So, if company came into existence, there is a need of employees. It means that all business operations are operated through employees. But if the turnover is more, volume of transaction is more. So, in order to protect the interests of shareholders or owners, there is a need of auditing. It means that accounts of company must be audited, that is statutory requirement. So, I am now going to discuss what is qualification required for company auditor. In regard to qualification of auditor, we are concerned with section 141 of the Companies Act 2030. Under it, the criteria of qualification is given. According to section 141 clause 2 of the Companies Act, the qualification of company auditor is described as only qualified chartered accountant within the meaning of Chartered Accountant Act 1949. It means that for appointment of an auditor of a company, educational qualification is required, that is chartered accountant. A person should have chartered accountant qualification and practicing certificate he can be appointed as an auditor of the company. Other qualifications are not considered here. It is the basic qualification, it is the required qualification. It means that chartered accountant can be appointed as an auditor of the company. Suppose a firm is formed by chartered accountants. Consider three chartered accountants came together and they formed a partnership firm for doing accounting related services. So, a partnership firm in which all partners having chartered accountant qualification, they can work in the name of partnership firm as an as auditors of the company. In case any partner so practices may act in the name of the firm. If the if the partnership firm is engaged with providing accounting services to the society or business houses, they can do audit of company in the name of partnership firm. On behalf of partnership firm, any partner that is chartered accountant is liable to sign an audit report on behalf of partnership firm. Third one, LLP. LLP means Limited Liability Partnership. Limited Liability Partnership firm can be appointed as auditor of the company, but only chartered accountant partners are authorized to act and sign on behalf of the firm. It means that we are taken here three parts of qualification. Was one at individual level, second at partnership firm level, and third one at limited liability partnership firm level. This is the qualification required for appointment of an auditor or auditors of the company. This is the one side of coin. Another side, that is tail side of the coin. Disqualifications of auditor. Now we are discussing for we are discussing about disqualification of auditor. In what sense auditor of a company proved as disqualified, or the following criteria given that are related with disqualification of auditor. For qualification, we considered section 141 plus 2, but for disqualification, we are considering section 141 again, but we are here considering clause 3 of the Companies Act 2013. The following persons are not qualified for appointment an auditor of a company. Number one, the auditing service is a personal service. The person having sufficient and legal skills, he may be appointed chartered accountant, is working as an auditor of the company. So this is personal service. It means that chartered accountant profession is coming under service industry. The nature of service is generally personal. Some services are related with public services, but in profession like doctor, chartered accountant, advocate, they providing personal services mostly. So a body of corporate cannot be appointed as auditor of the company. It means that any corporate body cannot be appointed as auditor. But it is noted that the liability of auditor is unlimited. Second, any officer of the company cannot be work as an auditor of the company. The term officers includes director, manager, and key managerial personnel. Third one, a person who is indebted to company in excess of rupees 5 lakh cannot be appointed as auditor of the company. Fourth one, a person who has given guarantee or security to the company in relation in the indebtedness of any third person of sum exceeding rupees 1 lakh. It means that a person given guarantee on behalf of third party regarding indebtedness sum exceeding rupees 1 lakh, he cannot be appointed as an auditor of the company. Fourth one, a person holding any security of the company carrying a voting right cannot be appointed as auditor. It means that a security holder of the company cannot be appointed as an auditor of the company. Any person who appoint will result the person being auditor of more than 20 companies. It means that a auditor has given ceiling limit about the audit of companies. A person can perform his audit work in relation to 20 companies. But a person having already appointment for 20 companies, he cannot be appointed as an auditor of the company. Seventh one, a person who has been convicted by a court of an offense involving fraud and a period of 10 years has not been elapsed from the date of such conviction. It means that a person who is not legally fit cannot be work as an auditor of the company. Eighth one, Section 144 of the Company Act 2013 also prescribes certain services not to be provided by the auditor without the approval of the board of directors or the audit company, but which shall not include the following services: accounting and bookkeeping services, internal audit, investment advisory services and banking services, management services, designing and implementing any financial information system, any other kind of services as may be prescribed, rendering of out sourced financial services, actuarial science services. It means that these services are not coming under the criteria of disqualification. So mostly we are focusing on 7 elements which are related mostly with the disqualification of auditor, and number 8 is an additional part of that. So we discussed two events independently. One is qualification of company auditor and another is disqualification of company audit. Then we are focusing removal of auditor. In what circumstances an auditor can be removed to work as an auditor. For that purpose, we are classifying the removal term into two parts. First part is removal of auditor or auditors before the expiry of time. And second part, removal of auditor or auditors after the expiry of the term. So these are titled as A and B. A is concerned with removal of auditors before the expiry of the term and B is considered with removal of auditor or auditors before the after the expiry of the term. Firstly, we are looking removal of auditor before the expiry of term. It means that before removal of an auditor concerned with earlier removal than prescribed time. An auditor appointed under section 139 can be removed from his office before the expiry of his term only by special resolution of the company and after obtaining the prior approval of central government on this behalf. Hence, for removal of auditor before the expiry of term, a company has required to pass special resolution and approval of central government is essential for that. Application can be made to central government for removal in form ADT2 with fees provided for the purpose within 30 days of the resolution passed by the board. Board of directors is the supreme power of the company. They have rights to take decisions for the interest of the company. So, if the board of directors is the executive body, they are, they are concerned with the decision making. So, it is the duty of board of directors after passing special resolution, the technical and official matter should be informed to the government within 30 days from the date of the resolution passed by the company. After the receipt of the approval of central government, the general meeting shall be held within 60 days of the approval. After getting approval from this central government for removal of an auditor before expiry of his term, then next step is approval taking from the general meeting within 60 days from the date of approval of the central government. I would like to repeat these three items in simple manner. Firstly, a company has required to pass special resolution. After passing a special resolution within 30 days, a company has required to get approval for such removal from the central government. After getting approval of the central government, a company has also required to take approval from general meeting within 60 days from the approval of central government. Special resolution is required to be passed in general meeting for removal of auditor, and in general meeting there is a need to pass special resolution. It is important to note that removal of auditor before the expiry of term, the auditor concerned shall be given reasonable opportunity to be heard in the general meeting. That is based on rule of natural justice. Rule of natural justice means provide justice to the affected party. For that purpose, a chance is given to an auditor regarding put in general meeting his opinion about it. It should be noted that even for reappointment of a retiring auditor is not automatic. That passing of a resolution in annual general meeting for its appointment is essential. So this is the matter related with removal of auditor or auditors from his duty before the expiry of term. In short, for removal of an auditor from his duties before expiry of his or their term, a procedure is laid down in the Companies Act that is summarized as: firstly, a company has required to pass special resolution, then it is necessary to take approval from the central government within 30 days from the passing of the special resolution. After the approval of central government, a company has required to conduct general meeting within 16 days, and in that general meeting a special resolution is also required for it. And lastly, a auditor is working for company before removing to him for duties. There is a need to hear auditor in general meeting. That is based on natural justice. Second part, removal of auditor or auditors. I purposely used the word here auditor or auditors. Auditor means single auditor. Auditors means the auditors involved in partnership firm. Removal of auditor or auditors after the expiry of the term. If the company decides not to reappoint the existing auditor, the following procedure is to be followed. This is if the company has decided to reappoint an auditor, the appointment procedure is followed. But on the other hand, if the company is not interested to reappoint the existing auditor, for that purpose, under mentioned procedure is to be followed. Special notice. The shareholder who intends to remove the auditor shall give 14 days notice to the company informing its intention to remove the auditor by passing the resolution in general meeting. It means that a shareholder it means that shareholders are the real owners of the company. They scattered all over the country. They do not participate in day-to-day transaction of the company, but they appoint their representative called as board of directors, and board of directors are responsible for taking major decision for the interest of the company. But there are shareholders have certain powers or rights. If the shareholders intends to remove an auditor, they have required to give 14 days notice to the company, and it is necessary to state by them what is the intention of such removal. Communication to the retiring auditor. The company, on receipt of such notice, should send a copy of the retiring auditing. After getting notice from the shareholders or shareholder, then company communicate that matter to the auditor, who is going to remove from his duties as related with companies. So communication is essential. Two types of communication. Mostly written communication is very important rather than oral communication. In written communication, a company writes to the retiring auditor or removing auditor about the notice given by the shareholders for removal. Representation by retiring auditor. The retiring auditor can make a written representation not exceeding a reasonable length to the company regarding his proposed removal. He may also request to the company circulate his written representation to the members. If the company is required to send the representation to shareholders only if the representation is made by the auditor within a reasonable time. Removal of an auditor after expiry of his term. Certain procedure is to be followed. Firstly, notice, statutory notice. Second, communication with retiring auditor. And third, one representation by the retiring auditor. Fourth, representation to be read. If the representation given by an auditor in written form is not circulated among the shareholders, the auditor may require that the representation be read out in the general meeting. If the written representation is not circulated to the members within given time, later on, oral representation is allowed. It means that the auditor may require give his representation in general meeting, right to attend the meeting. The auditor who is proposed to be removed from an inherent right to attend the general meeting, he can also make oral statement at the meeting as to his proposed removal. So retiring or the auditor which is going to remove or which is to be removed, that auditor has a right to attend the general meeting and give his oral statement about the removal. Not to abuse the right. The above privileges are extended to the auditor to protect his independence and prevent his unjust removal. So, this is the procedure followed for removal of an auditor from the company duties. So, in this lecture, we consider with three factors. One is qualification of company auditor, second is disqualification of company auditor, and third is removal of the company auditor. In removal of the company auditor, this this fact we classified into two categories: removal of auditor or auditors before the expiry of term, and second, removal of the auditor after the expiry of the term. In this way, we discussed the matter as related with the company audit, especially qualification, disqualification, and removal. In this way, I am concluding here my speech. Thank you.